Good afternoon. My name is Jason Stinnett. I am a staff attorney at Southeast Louisiana Legal Services. I handle consumer litigation and bankruptcy matters, Chapter 7 matters, out of our Baton Rouge office. Southeast Louisiana Legal Services is an LSC affiliate. We are a legal aid service for Southern Louisiana, Southeastern Louisiana. We provide back cost or no cost in some cases, legal services to indigent people who could not otherwise access the court system. Today, I'm going to be talking with you about bankruptcy. So let's move on and talk about consumer rights in bankruptcy. As always happens with these things, or frequently happens, we talk about how this affects you. I'm going to talk about some macroeconomic trends over the past 50 years. And then I'm going to tie it down to you individually, you, the listener here. And I want you to understand that it's not just you. So one of the things that happens is when we talk about consumer litigation, we talk about it's a definitional exercise. What is a consumer good? There is a body of law called the UCC, Uniform Commercial Code, defines consumer goods as goods that are used or bought for primarily personal, family, or household purposes. If you think about where your money goes, if you think about what your household budget, if you get a bank statement and you see where you've been making those payments over the past month, primarily goes to food, mortgage, rent, insurance, vehicle payments, a little bit of entertainment, eating out, things like that. Those are consumer purchases. Just about everything that you have is a consumer purchase. A better way to look at it might be, what isn't a consumer purchase? And you would probably be hard pressed to find something, maybe some sort of durable goods. Let's move on. So consumer spending takes up an incredible amount of GDP in this country. Consumer spending makes up for about 2/3 of Americans' gross domestic product. You see this figure of 70% sometimes, but it's been steady about that for decades. Last spring, spring 2020, the White House website set the number at 68%. So again, around that, and this is the St. Louis Fed. So that's what consumer goods are, what consumer spending is. But it doesn't remain stable. It changes over time. These are price changes in consumer goods and services over time. As you can see, starting about 20 years ago, 1997, increase in a lot of things: education, childcare, medical care, energy, housing, food, public transportation, gone up by at least 50% more in some instances. New cars and clothing are about stable, although the new cars is not accurate. We've actually seen an increase in the price of vehicles due to scarcity of semiconductor chips and also increased demand. It's even gone so far as to an increased demand and cost in used vehicles. The only thing that seems to have reduced is the cost of software, toys, and TVs, entertainment purposes. Isn't that funny or unusual, remarkable in some way? The cost of entertainment have dropped, but everything else has gone up. You know, it's easier to have to let yourself be placated while all of your other costs are just going up. So let's move on. This is actually kind of a famous graph here. In the post-World War II period of the American history, you see this productivity and hourly compensation are closely correlated. When a graph is closely correlated, you'll see a line one on top of the other, which is what we see until right about the mid-70s here. Productivity, compensation, and then it starts, there's this bifurcation. It goes in two different directions, with productivity increasing to 252.9%, over 250, and hourly compensation remaining at about 115.6. It's actually lower than that because I don't believe that this graph accounts for inflation. What this means is your parents, my parents, earned more money at their jobs than we do today because of the increase in productivity and the decrease in hourly compensation. I was looking it up before I came here today. You don't have to answer because I don't think you're able to. Does anyone know how much a tipped worker gets? The federal minimum wage for a tipped worker in Louisiana or at the federal level? It's $2.13 an hour. It hasn't gone up in decades. That's all that you have to pay somebody per hour per their wages. It is $7.15 for that's the federal minimum. So minimum wage, basically what you're seeing is people working harder, working longer hours, and not having as much money. Their money doesn't seem to be going farther. So what happened is, as goods and services became more expensive, the wages remained stagnant. They remained roughly the same. So consumers, they developed coping strategies as a way of trying to survive this. Women moved into paid work in greater numbers during the 70s, 80s, and 90s. Some of you may have done so yourself. Some of you may remember, family members doing so. Everyone started working longer and longer hours. 40 hours a week, 50 hours a week became the new normal. And this is sort of a latchkey kid generation of Generation X and millennials. And also, importantly, savings dropped and everyone started borrowing from creditors. They borrowed to the hilt. Why? Because you weren't making enough money. Your money was not going further or as far as it had been. So ultimately, I wanted to bring it back to this. It's not just you. This is something that has been going on in this country for decades. And it is a baffling problem. It is a difficulty. We're not raised to speak about money publicly. You'll tell a stranger on the bus your medical complaints or that one family member that you just cannot stand, but you won't tell your nearest friend, your dearest friends, how much money you have in the bank account, because we don't talk about that in this way. The reality of the situation is almost everybody in this country owes money. I do, you do, millions of Americans do. In fact, so many people owe money in this country that according to a recent publication back in 2019, only 61% of Americans could cover a $400 unexpected expense with cash. This was couched in the question was couched in terms of an unexpected mechanics bill or an unexpected medical bill. If you had to go to the ER, could you cover it? And many people could not. And it's not just you. So with an aim to try to offer some sort of upshot, some sort of silver lining to what I'm about to say or what I have said. Here are ways that you can establish good credit habits. They're pretty common. You can Google them. Make a budget. Make a budget, figure out how much money is coming in every month, how much money is going out every month. Everybody has a smartphone these days. You have a calculator built right into that. You can just sit down with a piece of paper and figure out, this is how much money I make every month. This is what I'm spending on rent. This is what I'm spending on my car note. This is what I'm spending on X, Y, and Z, and figure out where a lot of your money goes. Frequently, the thing that I see, especially these days, is the transportation is the thing that really hurts a lot of people. Rent to a lesser extent, but transportation, insurance, gas, maintenance on the vehicle, that really is the thing that puts a lot of people in the hole. Another thing that some people, well, they won't tell you is if you're paying a car note and you get involved in an automobile accident, you still have to owe on that car note. I have many clients who don't realize that. Another thing that you can do is talk to your creditors. They're not ogres, at least I've never met them, but I've never believed them to be ogres or monsters of any caliber. They're people, they're human beings just like you and I, and they want to be paid. If you call them up and say, look, I'm having a little bit of trouble, I want to deal with you, that's more receptive than just silence from you. You can, in some instances, make some headway with your creditors and negotiate with them, but by the time that you're having to have these conversations with your creditors, it might be, it might be time for different conversations to be had. You can also check your credit reports, what your credit report is. So your credit report is not your credit number, your credit rating, your worthiness of somebody lending you money. What your annual credit report is there are three, there's multiple, but there's three big credit reporting agencies, TransUnion, Equifax, and Experian. Several years ago, they entered into a settlement with the federal government where they gave every single American citizen, and for every 12 months, one free credit report. There's a website you can go to, it's annualcreditreport.com. Don't ever pay for this, you can get it for free. There's a lot of ads if you Google it, but if you go directly to the website, you can get it emailed to you. You can even get it mailed to you. You can do it over the phone. And it's a way for you to figure out who you owe money to. Sometimes, and this is regrettable, but sometimes there's instances of identity theft. And we've been on an uptick of that lately. Credit card scams, the gift card scams, charity scams, contractor scams, that type of thing. And once you give that information out, it can be a little hard to figure out, who has your information and what your rights are. First thing to do is to go out, get your credit reports, see where you have open accounts, see what you can do about it, because there are, you can report these things. You can report discrepancies under what is known as the Fair Credit Reporting Act, which is, absent perhaps a recent Supreme Court case, is fairly effective and toothsome piece of federal legislation. Mark, could I get my water from over there? Thank you. Avoided debt traps. So what is a debt trap? A debt trap is sometimes there are consumer financial services and companies out there who are so good at what they do that they have created these traps where you just make payments on it every month and you're just running on a treadmill. You're not attacking the principal. Thank you, sir. You're just paying down the interest every single month. I can take you through a hypothetical, but it's usually something like the interest is being compounded at a higher and higher rate, so that you're never able, you make these payments every month, but it seems like you're never able to fully get it down. And that is, in some instances at least, by design. Imagine the business model, if you would. No more perfect than this. You do very little every month and somebody just sends you a check. So there's an incentive. Well, why don't we see if we can make this as long as possible, right? We could just ensure that I sit here and I keep getting paid, and that other person continues to pay me because that's their obligation. And if they don't, I'll threaten them with court and I'll threaten them with garnishment. Always be very careful about these. And the courts do not like breaking agreements. They don't like voiding contracts if they can help it. And there's a saying, it's Latin, it's old, it's in the law. It is caveat emptor, which means buyer beware. If it sounds too good to be true, it probably is. You see high fees, high charges that you're having to pay just to engage in this sort of transaction, walk away from it. Walk away from it. I'm going to sleep on it. I'm going to think about this. Something about this doesn't feel right. The last thing that I have down here is judgment proof or collection proof. Louisiana has a number of laws, one of which is the revised statutes, Louisiana Revised Statute 133881. And there are others too, but this is the one that deals with personal property. These are the things that your creditors can't get from you. They can only take 25% of your gross wages to garnish you. They can't take more than, you get to keep $7,500 worth of equity in one vehicle per household. There's a number of other things in there too. It's not great. It is primarily agricultural in nature. The Louisiana State Legislature did amend it a couple years ago, but it was only to increase the allowable monetary amount of firearms and ammunition that you could exempt from your creditors, which is now, I believe, $5,000. You can keep your cow, but you can't keep your television from your creditors or in bankruptcy. So it's not great. You do get to keep your household goods. That's one of the few good things. But ultimately it comes down to this. I run into people who have a number of credit cards or who have gone and signed notes with local finance companies. There's a lot of them around here in Louisiana, especially around here. And they're underwater. They want to pay their creditors back. Every now and again, it's very important for a client to tell me, it didn't used to be like this. I was always one of those people who made my payments. I paid my bills on time because it's a point of pride for them. Until I got sick, until the accident, until something happened. There's some sort of event, and life is full of them. Which is why we have the next thing that I'm going to talk about, which is bankruptcy. So I handle what are known as Chapter 7 bankruptcies. Bankruptcies are federal in nature. The federal government, it's actually in the Constitution, and according to Judge Douglas Dodd, who is the bankruptcy court judge that we have in the Middle District, which is the parishes surrounding Baton Rouge, he opined that some of the founding fathers themselves declared bankruptcy at a recent hearing that we had. The court is now open. They had a hearing in the court not too long ago, the end of last month, and I attended. Most of that's by telephone now, but it was nice to be back in that old building. It's downtown Baton Rouge, right across from the court, from the big post office right down there. Anyways, bankruptcy is at least Chapter 7. There's different ones. It is getting a fresh start is the way that it's analogized. It is a clean slate. It is a mechanism, and it is long, and it is there's a lot of paperwork involved, but you can get to it, where you end up getting something called an order of discharge, which wipes away all of your debts. That's one part of it. Discharging all of someone's obligations, getting them to a point where they can breathe easier, they can start fresh, and then they can move on with their life is pretty compelling. And it's also very potent, which is why during the end of the 20th century, the beginning of this one, a lot of the creditors tried to stop it. What happened, if you go back and look at it, is it had to do with credit cards and credit card companies. Some of you who may be watching this or may watch it at some point in the future might remember a point during the 80s and 90s where not everybody had a credit card in their wallet. If you did, you were doing very well. If you did, it had a high interest rate. But somewhere along the way in the early 90s, somebody figured out that they could market these things as financial services, financial products to middle-class Americans. 0% APR, this, that, and the other. And so people took them up on it. And you saw this explosion of people everybody had a credit card. Well, everybody had a credit card, and some people were running up debts, and they were discharging them in bankruptcy. Bankruptcy is prior to 2005, and I've looked at a lot of records to say this, relatively easy. I'd see them over and done within about 6 months, looking at some of the records. That was not acceptable to the credit card companies. So they tried to change the bankruptcy code once in the 90s, and they failed. And they tried again once more in the late 90s, early 2000s, and they failed again. And finally, they were successful during the Bush administration. President George W. Bush signed the Bankruptcy Abuse and Consumer Protection Act of 2005. Made it much harder for consumer debtors to discharge, to get rid of their debt. New and stricter requirements were employed. People could lose their houses now in bankruptcy. They had to take a number of courses. They and their attorneys had to swear to this, that all the information was true and correct under penalty of perjury. Perjury is lying under oath, is a federal felony, investigated and prosecuted by the FBI and the Department of Justice, and a number of other different things were added to it. The legislation itself it took the courts a number of years to craft some solutions to it because it was not very well put together. And there were a number of other special interests that invade in the process. And they had, certain things are non-dischargeable. Student loans, for instance, are non-dischargeable, generally speaking. We are here in the Fifth Circuit. We follow what's known as the Henry-Bruner test. Very hard to discharge student loans. Although there was a recent case, Henry Crocker, but I don't think I've seen anything after that. Child support is another thing that is non-dischargeable. If you killed somebody while you were drunk driving and their family filed, or their estate filed a wrongful death claim against you and got a judgment, that was also something that could not be discharged in bankruptcy. So, as I said before, there's different types of bankruptcies. We have Chapter 7 or Chapter 13s. Chapter 13s are 3 to 5 years, and based on some recent numbers that I saw, somewhere in the neighborhood of about 30 to 50% of the people fail to complete those. In fact, in Chapter 7 bankruptcies, there's an impetus to push people from a Chapter 7s to a Chapter 13s. Why? Chapter 13s, you pay back your creditors. You enter into a plan, which has to be confirmed by the court, where you pay back your creditors over a term of years, 3 to 5 years. A lot of people fall out of them just because, well, heck, where were we all 3 years ago? It's July of 2021, as I say this, things were a lot different 3 years ago, 5 years ago. Your lives were different too. It's different to plan for these things, but some people do complete them. Chapter 9 are municipalities. Very few townships, municipalities file bankruptcy. There are a few of them, though. I think there was a recent one, either out in California or Michigan. I say recent, probably within the past 10 or 15 years. Chapter 11, businesses. Businesses are treated as, Louisiana would call them, juridical persons, but entities. They can file for bankruptcy and get rid of their debts. Family farmers and fishermen, special bankruptcy chapter under Chapter 12, and there are others too. In fact, we have a new one in there. I should probably throw that in. Okay, so how does it work? There's a lot of paperwork. All of the sorry, we're having some, there we go. All of the forms for bankruptcy are available online. You can Google it, or Bing, whatever you use. It's uscourts.gov, and it lists all of the forms that you need. Well, what forms do you need? You need to talk to the bankruptcy court. There's generally 23 forms that you need to prepare, or that I need to prepare for my clients in order to file a bankruptcy. It's long, it's time consuming. Organizing the forms. There's a couple of ways that you can do it. You can do it by hand. I've done that. It took me and a client about 3 days working cheek to jowl, pen and paper, just going through everything. Well, this over here and this over here. There are computer systems that enable you to do it. I have one that I use in my office, which is known as Best Case. It's pretty good. It's not great. There are others out there. There's also something called Upsolve. Upsolve is a bankruptcy system of some kind. It's funded by the LSC, Legal Services Corporation. Potential debtor comes to the website, answers a bunch of questions, and the forms are generated for them. I think it's like 20 questions. They do tell you to take it by an attorney. I've had clients do this. It, again, is not great. Why isn't it great? Because your financial life is unique. It is, it has nuances to it. It has its own character. There are things that you want as an individual that, I want to keep this. This is not something that I want to part with. Being able to say that to somebody. So there is a lot of paperwork involved. It is not impossible to organize all of those. More on that later. I'll dive into it. So filing, you get all your paperwork together, every I dotted, every T crossed, and you file it. And once you file your bankruptcy, something magical happens. It's called the automatic stay, and that is your first safe harbor. So what the automatic stay is by federal order, by what we call, it's a estoppel principle or an injunctive relief. It stops, it stays your creditor from contacting you in any way, shape, or form. No more phone calls. I have a number of clients who say, I didn't realize how tired I was. I didn't realize how much I needed this. Like, just to be able to pick up my phone and not feel afraid that it's going to be somebody yelling at me about how much money I owe them. Getting mail, going to the mailbox without a sense of palpable dread, you know. Court proceedings are enjoined too. That means that if somebody's suing you, that stops. In many cases that I have, unfortunately, I've some, it's probably many now that I think about it. You know, you notify the court, we filed for bankruptcy. Here's a notice. This proceeding is done. It can go no further. Garnishments are another thing too. I just had a conversation with somebody today, in fact, about garnishments. Garnishments, for those uninitiated, somebody gets a judgment against you, and then they can start taking 25% of your gross income. It is ruinously destructive for many working class people in this state. You cannot manage your finances. As I pointed out a few slides back, most people can't afford, you know, a $400 cash payment if they had to. And again, some of these companies, with the financial service companies, consumer finance companies, what they do is they will sit on a garnishment for terms of years. And they'll get a $2,000 judgment against you because you didn't pay on a promissory note. You borrowed some money some years back. You don't remember how long ago it was. They got a judgment. You had some paper, but the paper come back on you. And now it's years later, and that judgment, which is for $2,000, is now $8,000. And it's coming out of your paycheck every month, and you don't understand why. The automatic stay puts an end to that too. And that is something that is a service that we offer, because that is another sense of relief. You know, I suddenly have all the money that I, you know, that I lay claim to, that I earned. One of the other sort of central a priori type of guiding principles of bankruptcy is to treat all your creditors equally. But like good attorneys, we have a number of exceptions to that, and I'll get to that in a moment. But you treat all your creditors equally. You want to list them in your bankruptcy because you want to get rid of that. You don't want to have a debt that you owe to somebody. You go through the process of filing for bankruptcy, all this work, all this paperwork, all this time, and find out that after you get done, yes, actually, I do owe some money to somebody else on the other side. And you can only get a Chapter 7 once every 8 years. Well, that's not accurate. You can get an order of discharge, which wipes away your debts, once every 8 years. There are lesser periods, again, with the impetus that people would file Chapter 13s. I think from a 13 to 13, it's 2 years. From a 7 to a 13, it's 4, and then from a 13 to a 7, it's 6. But from a Chapter 7 to a Chapter 7, it's 8 years. So again, that was one of the changes that BAPSIPA brought about. Last thing, secured and unsecured property, secured and unsecured creditors. Collateral is the big thing there. Easiest thing to understand about secured property, secured transactions, car note, house note. If you don't pay on it, they'll, you know, repossess it, begin foreclosure proceedings. That's what secured property is. That is treated differently in bankruptcy than unsecured property. Unsecured is credit card debt. That's a big example of unsecured debt in a bankruptcy, and also, you know, any other property that you might own, the way that people understand it. Okay. Credit counseling, right. One of the changes in BAPSIPA was for a credit counseling course, not one, but two. You have to enroll in a course prior to filing for bankruptcy. I remember watching a CLE probably within the past couple of years. There was an attorney on there from the New York area, and he said, by the time that clients come into his office, you know, to enroll in credit counseling, it's a little bit of an insult because they're probably about 6 months past the point of needing it. But it is a requirement. If you don't have it, your bankruptcy is closed by operation of law in 48 hours. And if your bankruptcy is closed, having to reopen it again requires more paperwork, more time for the, generally for the attorneys. Sometimes there are what we call pro se. That means representing yourself, pro se debtors who do and can and do get through their bankruptcies. Those are rarer individuals that are uncommon. There's a lot of steps to this process and traps for the unwary, and it was done intentionally. Additionally, you have a second course that you have to enroll in after you have started your bankruptcy, which is a financial management course, debtor's education course. So there's two. There's one to open it and there's one to close it. You close it, you get your order of discharge, all of your debts are discharged then. There's a website maintained by the Department of Justice. It changes. There's one for each district. Districts in Louisiana are the Western, Middle, and Eastern District. I'm speaking now in what is the Middle District of Louisiana. But these are requirements that were changed in 2005. Okay, exemptions. Exemptions are good. Exemptions are things that you get to keep. I touched on it briefly. Restatement 133881. There's also a homestead exemption at Restatement 20:1. This is it's sort of due to Louisiana law. There are exemptions built into the bankruptcy code itself, which is federal. You can keep stuff there, but there are certain states, and Louisiana is one of them, that says you do not get to use these. You have to use ours. Other states let you choose, but this Louisiana says you have to use our state exemptions. Other states differ, but it depends on where you are at time of filing. So in Louisiana, you have to use these things, and you can't have a lot of, well, I might be getting ahead of myself here, but one of the things that they look for, red flags in bankruptcy, is a lot of transfers, a lot of changes beforehand. Some people think, well, if I'm going to discharge everything, I may as well take these credit cards and run up a big bill on it because I know that it's going to be taken care of. And that's not the case. A creditor can say, there's a presumption of fraud that is non-dischargeable, and you will have to pay that on the other side. So additional concern there. Open hands, clean hands, that's the way to go through this process. Okay, so you're getting ready to file for bankruptcy. And let me prepare you for the word of schedules. Schedules are where the meat and integument of your financial life lies. They're alphabetical, A/B, C, D, E, and F, G, H, I, and J. I'll try and go through this pretty quickly. A and B is where you list all your property, real estate that you might own, any airship, vehicles, and then personal property. They want to know everything that you have. And I do mean everything. Property comes down to a lot more fine detail than you might expect. I'll give you one example. One of the admonitions that the trustees, and trustee is an individual who is appointed to oversee this process. They're like a watchdog, or analogize as a federal prosecutor. One of the things trustees say is, are your parents still living? When we have our first meeting, a meeting of the creditors about 30 days after you file for bankruptcy. And the debtor will usually answer yes, and I try and prepare my clients for this. What your parents still living with the trustee is trying to get some information at relates to something in the law of successions, wills, estates, which is property transfers on the moment of death. So if you have a parent or any sort of somebody who you stand to inherit from, if they die, if they pass on to their great reward, you get all of their stuff at that moment of death. That's the way that the law is treated. So if you're in bankruptcy and that person dies, you stand to inherit it, suddenly that becomes property of the bankruptcy estate, which is going to be administered, which means the trustee may take that in order to satisfy your debts. Some people don't like that. So it's one of the reasons why the trustees try to prepare people for it. Next, we go into exemptions. I've spoken about that. There's a list of them. This is the stuff, again, that you get to keep. Household goods, you get to keep your pets, and COVID relief thing, stuff, that's a recent one. Some of your tax refund, not all of it, some of it. This is stuff that you get to keep in bankruptcy. D, E, and F go into your creditors. You got to list all your creditors. You want to catch them all. It's Pokemon rules. I say to my clients, some of you are old enough to think that's funny. I think it dates myself a little bit. But you want to ensure that these people are aware that you are filing for bankruptcy, so they don't bother you anymore. They don't send you things, and they don't, file lawsuits against you, and that you can discharge the debt at the end of it. D are for secured creditors. E are for what is a hybrid. It's known as priority unsecured, which is primarily tax debt, and then F are your unsecured creditors, which usually take up the lion's share on these types of forms. G, executory contracts and unexpired leases. Rent, utilities, things that are still ongoing. That's what executory means in this context. H, co-debtors, anybody else you own property with. A lot of you parents out there, you got a kid, that kid has a car, you had to co-sign for the note. That makes you potentially a co-debtor for them. Last, we have income and expenses. You go through, you list all of your income from all the different sources, and then J, all of the expenses, where that income goes. So, as I was saying, about 30 days after you file for bankruptcy, there is a scheduled meeting of the creditors. It's called a 341 because we're not very creative as bankruptcy attorneys. That is the code provisions, 11 U.S.C. 341. They're done by phone these days due to COVID. They used to be in person on, I believe it was the second floor of the bankruptcy court. It's on Florida Avenue, 700 block. About 30 days after filing, you will show up. There'll be other people there. It's, on the phone, your name will be called. You'll be sworn under oath. And then you have to answer questions by the trustees. There's 3 trustees in the Baton Rouge area. All of them are pretty good. Sometimes I have an adversarial relationship with them, but they're all very competent professionals. And they go through, they ask the questions of the debtor and try and determine what property belongs to the bankruptcy estate for their administration, what the debtor gets to keep. Additionally, there's a reason it's called for the meeting of the creditors, is your creditors can show up. Very rarely do they. I think I've had the past 2 years that I've been working on this docket, twice has a creditor showed up. But it does happen. The creditors are permitted to appear and then ask questions of the debtors there. So what happens after that? Well, after the 341, there are these sort of documents that are still needed. You get those to the trustee, and then you wait. You get that second financial management course that I mentioned beforehand. And then you get the order of discharge if there's no other problems in the process. Trustees have been provided with all of their documents. Everything is accounted for. You've listed all of your creditors. You had the 341 and nobody came. All the people who were bothering you beforehand have stopped bothering you beforehand because of the automatic stay, and it's pretty quiet. And then one day you get a call from your attorney and the order of discharge has been granted. It's been signed by a federal judge, and all of your debts are now gone. And that is the brass ring. That's the reason that you go through this process. And you think that maybe that's the end, but it's not. You got a little bit more time. So how does a case get closed? Trustee finishes administering your estate, says, this is how much I can take, this is how much I need to keep, this is payments that were made to me. And then they file those documents with the court reviews those documents. And if it finds them complete and to the court's satisfaction, they enter an order closing the case. Now that means that the case has been closed, but it can also be reopened in some instances. Generally speaking, when they find that there's assets, something that they forgot to do. I had a recent one where there were just some more assets. So we reopened, we dealt with it, and then closed it. If this sounds a little bit boring, if this sounds very procedural, it's because it is. It's designed to frustrate people. It's designed to kick them back. It's designed to be something that people like myself, as an attorney, can assist you with. But there are, it's a bit of a hard climb. Now there are people out there who do it. themselves, but it can be difficult. So in conclusion, I'd like to cite something from a professor out at Emory, Professor Rafael Pardo, using an original data set of educational debt dischargeability determinations. Article reveals that even when controlling for a variety of factors, including debtor's financial characteristics and applicable legal standards, the typical self-represented debtor in such proceedings has only a 28.5% chance of litigation success, which pales in comparison to the 56.2% success rate of a similarly situated debtor who is represented. Now, what the heck does that mean? It means that if you file a bankruptcy by yourself, you have, in this, according to this study, about a 28.5% chance of winning. If you get an attorney, you have a higher chance, almost double chance of success. Now, I think that this is educational debt dischargeability. So that is relating to educational debt, but it also speaks to the larger process. Bankruptcies are, I think, probably too complicated, but they're absolutely necessary. There's a lot of people out there who are not getting by, and you need a fresh start. You need to breathe. You need to get these people off your back, get them off your phone, and find some way to move forward. And there are resources out there for you. There are people like myself and other people at our organization who are willing to assist you. If you have the means to do so, there are also private bankruptcy attorneys out there. You can do it yourself. All the forms are available online as public domain. The clerks at the court are very, very good. I have nothing but good things to say about the clerks in the Middle District Bankruptcy Court. But they are not attorneys, and eventually they'll get to a point where they say, I can't answer that question for you. That is a legal question. I'm not permitted to give a legal opinion or give legal advice in this regard. So if this is something that you need, try and find a consult with an attorney, particularly a consumer bankruptcy attorney who may be able to assist you. I think that's about all that I have to say on this subject. Ms. Henry? Okay. All right, well, any questions? I'm going to see that there's a couple people on 2.3 and stay lifts. How do you lift a stay, an automatic stay? I think that's what that means. Please repeat our contact info. SLLS.org, that's our website. You can go there and you can find, I don't know exactly where you are, Trey, but you can find one of our local offices. It is Southeast Louisiana Legal Services. It's an acronym, SLLS.org. Our intake line, I think I have that up here. Let me see if I can find it real quick. No. At least for the Baton Rouge office, it's 225-448-0331. 225-448-0331. That's all I have. Thank you very much. Let me stop this share. All right.
Thank you very much.
You're welcome.
For coming out.
All right. One in closing, just one more thing. 225-448-0083 is our intake line, and our website is southeastlouisianalegalservices.org. You can find our office locations all around the Southeast Louisiana area. Thank you very much, and have a nice day. Good luck.